Let's put a definition to employee relations. Employee relations is the working relationship between the employer and the employee, which encompasses the rights of each party, how decisions are made, and how problems are resolved. In union companies, this function is also called labor relations or industrial relations. A major step toward establishing industrial peace occurred when federal laws endorsed collective bargaining as the primary method of resolving disagreements. This section briefly reviews the history of labor unions during the past 2 centuries. While this information is not typically tested by HRCI, understanding the history of the labor movement is essential for understanding the labor laws that exist today. Prior to the National Labor Relations Act, most working conditions were deplorable. Small groups of employees would band together to attempt to get their employer to make better working conditions. They were met with hostility and often violence. In 1935, the National Labor Relations Act, also known as the Wagner Act, established the legal right for labor unions to exist. During the 1800s, 4 major tactics were used against unions. Conspiracy doctrine, court injunctions, yellow dog contracts, and antitrust statutes were the 4 major weapons used against labor unions. A conspiracy doctrine is a weapon used against labor unions in the early 1800s where judges found that unions caused or planned to cause an injustice to other people or society. A court injunction is a court order that directs a person or group to refrain from pursuing a course of action. In most cases, an injunction is used to protect property rights, which include the rights to hire workers, to sell goods, and to run a business in a profitable manner. A yellow dog contract is a statement employees were required to sign in which they agreed not to join a union. Now, antitrust statutes are used widely today. They are designed to protect consumers from predatory business practices by ensuring that fair competition exists in an open market economy. Union leaders thought the Sherman Antitrust Act of 1890 would protect them from powerful and hostile corporations. Although this law made no specific references to labor organizations, Unionists found that it limited a variety of vital union activities. Unions were interpreted by the courts as illegal combinations in restraint of interstate commerce when they attempted to strike an employer or to boycott an employer's products. The Federal Anti-Injunction Act, also known as the Norris-LaGuardia Act, encouraged the formation of labor unions by neutralizing the power between employees and employers. The primary focus of the act was to limit the use of court injunctions. Although Norris-LaGuardia restricted court interference in labor disputes, it did not restrict interference from other parties, especially employers. Crazy things went on. Employers hired agents from their own organizations or from professional detective agencies to spy on union members. We call this industrial espionage. These spies tried to destroy the union from within by advocating violence and destruction, by discrediting union leaders, and by destroying the faith of other workers in the union. Many union leaders were killed or beaten by hitmen hired by employers to discourage union activity. Many employers tried to destroy the union by making strikes ineffective. Some strikes were broken when employers refused to negotiate with the union and encouraged workers to return to work. A less violent method of controlling union activities was for a company to organize and dominate its own union. These company unions sometimes attempted to resolve worker grievances, but they usually did not allow for genuine collective bargaining over wages and other important issues. A company union ultimately represented the interests of the company and not the employees. The National Labor Relations Act, and this is one historical piece of information you must know for the exam, regardless of if you're taking a PHR or SPHR, and you also need to know this for your career in human resources. The National Labor Relations Act, also known as the Wagner Act, established employee rights to self-organize, to form, to join, or to assist labor organizations, to bargain collectively through representatives of their own choosing, to engage in concerted activities, and you need to know that term, concerted activities, for the purpose of collective bargaining. Congress identified 5 unfair labor practices and declared them unlawful. It is an unfair labor practice for an employer to interfere with, restrain, or coerce employees in the exercise of their rights. It is an unfair labor practice for an employer to dominate or interfere with the formation or administration of a labor union. It is an unfair labor practice for employers to allow union membership or activity to influence hiring, firing, promotion, or other employment decisions. It is an unfair labor practice to discharge or discriminate against an employee who has filed a charge with the National Labor Relations Board or given testimony to the NLRB. It is an unfair labor practice for an employer to refuse to bargain in good faith with representatives of the employees. The Wagner Act, or the National Labor Relations Act, established the NLRB and gave it the authority to administer the act in a peaceful and democratic manner, or other mutual aid or protection. The National Labor Relations Act was amended in 1947 by the Labor Management Relations Act, popularly called the Taft-Hartley Act. The Taft-Hartley Act amendments concerned 4 basic issues: unfair labor practices by unions, rights of employees as individuals, rights of employers, and national emergency strikes. Under the Taft-Hartley Act, unions are not allowed to restrain or coerce employees in the exercise of their collective bargaining rights. Unions are not allowed to force an employer to discriminate in any way against an employee in order to encourage or discourage union membership. Unions are required to bargain in good faith with employers regarding wages, hours, and conditions of employment. This requirement means that unions must make the same good faith efforts as employers to meet and make counter-proposals in a sincere effort to reach agreements. Unions are not allowed to conduct certain types of strikes or boycotts. Unions are not allowed to charge excessive initiation fees or membership dues when all employees are required to join a union shop. And unions are not allowed to force employers to pay for work or services that are not needed or not performed, a practice called feather bedding. Anytime any organization gets too much power, it lends itself to abuse. So by the 1950s, we were seeing things like misuse of union funds, extortion, crime, etc. The Labor Management Reporting and Disclosure Act was enacted to regulate the internal conduct of labor unions. It requires a Bill of Rights for union members, reports to the Secretary of Labor, union trusteeship, conduct of union elections, and financial safeguards. The major provisions of this act are still relevant today. It grants equal rights and privileges to every union member with regard to the nominating of candidates, voting in elections, attending union meetings, and voting in these meetings. Every member is given the right to meet and assemble freely with other members to express views, arguments, and opinions. Increases in dues and fees must be approved by the union membership majority. Members who have been wronged by the union and cannot obtain justice through normal union procedures are guaranteed the right to sue the union in a civil suit. Union members may not be fined, expelled, or otherwise disciplined except for non-payment of dues, unless certain procedural steps are taken to ensure due process. The Act requires unions to follow democratic procedures in electing officers and creating union policies. file reports with the Secretary of Labor, report all the money, benefits, special loans, or other things of value they receive on Form LM30 to the U.S. Department of Labor if they or their spouses or minor children have certain interests or dealings related to an employer whose employees their union represents. Union representation of employees. Local unions generally represent a group of employees working in one area for a particular employer. Local unions vary greatly in size and power, from as small as less than 10 members to as large as more than 40,000 members. National and international unions are collections of local unions, usually in the same industry. They have their own constitution, which establishes the rules and conditions for chartering the local unions. Most national unions have the power to approve or disapprove agreements negotiated at the local level, to decide whether a strike by a local union is legitimate, to supervise elections of local officers, to audit the records of local unions, to remove local officers for improper actions, and to place the local union in trusteeship for violating the national union's rules. Local unions also are required to pay dues to the national union. In return for what they receive from local unions, national unions provide a variety of services for the local unions, such as education and research, public relations campaigns, lobbying activities to influence legislation, communications to members, and administration of benefits and pension plans. The AFL-CIO is a large and powerful federation of labor. 57 national unions plus numerous independent local and regional unions belong to this federation. The AFL-CIO represents approximately 12.2 million workers. The chief governing body of the AFL-CIO is its executive council and representatives from the national unions who meet every 4 years and set policy. The AFL-CIO also has a large staff that provides information, advice, research, and public relations for the national and local unions. In 2005, 7 national unions formed a new coalition called Change to Win, because of their dissatisfaction with the AFL-CIO. Their dissatisfaction stemmed largely from the AFL-CIO's extensive involvement in political campaigns and inadequate efforts to recruit new members. Since these were some of the largest members of the AFL-CIO, their disaffiliation significantly reduced the AFL-CIO's membership and budget by about 1/3. It is unclear whether Change to Win will act as a competing federation challenging the dominance of the AFL-CIO and its affiliates, or merely as a loose confederation of unions that coordinate efforts for the purpose of organizing. The new coalition, which is now down to just 4 unions, declared its intention to focus on recruiting new union members at the local, national, and international levels, and especially on employees working for large international companies. The union business representative performs a crucial role for the local union in contract negotiations, grievance proceedings, and in managing the local union headquarters. The business representative is usually a paid position by the local union. The union steward is normally an employee of the company that represents the union at the company. Contacting the union steward is the first step an employee takes if they have a grievance. The union steward helps to reconcile the grievance at the company level before filing a formal complaint. The National Labor Relations Board was established by Congress through the Wagner Act. The purpose of the NLRB is to protect the rights of employees, employers, unions, and the general public. To protect these rights, the NLRB performs 2 major functions: conducting representation elections and resolving unfair labor practices. How to organize a union. The first step is to get at least 30% of the workers to sign authorization cards calling for a union to represent them. Then you can request permission from the NLRB to hold an election. The NLRB then investigates 4 issues: whether the company falls within the jurisdiction of the NLRB, who should represent which workers, whether there is enough worker interest, and whether there are any election bars, such as another petition has been filed within the past year. Within 7 days after the regional director has approved a consent election, the employer must file an election eligibility list containing the names and addresses of all eligible voters. This is called the Excelsior Rule. The NLRB has adopted specific guidelines for determining which employers are subject to the Wagner Act. These guidelines are based on industry classifications and gross dollar volume of business. Retail firms, service establishments, and restaurants, for example, must have a gross volume of $500,000, while some healthcare institutions are covered with a gross revenue of only $100,000, and some non-retail firms with only $50,000. The NLRA establishes the following rules regarding the formation of bargaining units. Professional employees may not, without their consent, be included in a unit that includes non-professional employees. Craft workers may not be denied their own unit merely because they were formerly included in a different unit. Guards cannot be included in a unit containing other occupations. New elections cannot be conducted by the NLRB under certain conditions, called election bars. The purpose of a bar is to preserve the integrity of the bargaining relationship and afford new unions an opportunity to represent workers without having their legitimacy challenged. A valid election was held during the preceding 12 months is called an election bar. A valid union contract already exists is called a contract bar. A prior election petition was withdrawn by the requesting party within the past 6 months is a prior petition bar. The initial year following certification of the union has not elapsed. We call that a certification bar. A reasonable period has not elapsed after a union has been recognized by the employer. This is called a voluntary recognition bar. An unfair labor practice charge affecting the proposed bargaining union is pending is called blocking charge rule. The goal of a union is to become the exclusive bargaining representative of employees through an NLRB certified election or voluntary recognition. Certification of the union by the NLRB occurs after an NLRB conducted election by secret ballots in which the union receives a majority of the valid ballots cast by the employees eligible to vote. A union can also be certified by the NLRB as a result of an order issued by the NLRB as a remedy for severe unfair labor practices committed by the employer during the union organizing campaign. Employers can voluntarily agree to recognize a union as the representative of their employees. Elections using secret ballots are conducted by the NLRB. Representatives of the management and the union are entitled to watch the election procedures to determine that only legitimate employees are given ballots. Once the election has been conducted, the outcome is certified. To win, the union must receive the majority vote. That's 50% plus 1. A union can be removed through a decertification election. The process for decertifying a labor union follows the same procedure as for organizing one. The NLRB must receive a petition from at least 30% of the workers calling for an election. After the usual investigation, election is held. If less than 50% vote in favor of the union is decertified. Deauthorization differs from decertification. When employees vote to decertify their union, it ceases to be their bargaining agent and the employees cease to pay union dues. Decertification only requires a simple majority of those voting. Deauthorization provides a means for union members to hold union officials accountable for their leadership. In a deauthorization election, the employees do not remove the union as their bargaining agent, but they can withhold paying union dues. Deauthorization elections are supervised by the NLRB, and they can occur at any time during the life cycle of a contract and may occur annually. When an employer is notified that the employees have petitioned for an election, the employer can consent to the election and agree to a date. About 85% of union elections are consent elections, and they occur 42 days after the petitions are received by the NLRB. The employees covered by the Wagner Act include regular full-time employees, part-time employees, seasonal employees, day-to-day workers, former employees who have ceased work because of a current dispute, and even applicants for employment, since applicants cannot be rejected because of pro-union attitudes. Employees who are excluded from coverage of the Wagner Act include managers who create or implement policy, independent contractors, employees who work for the employers who are not covered by the Act, confidential employees who assist management in negotiations, agriculture, laborers, domestic servants, individuals employed by parents or spouses and students, and supervisors who exercise independent authority and judgment. If there are no challenges to a union election, the results are determined by a majority vote. If the union wins a majority of the votes, it is certified as the bargaining representative. If the union does not win a majority, it is not certified and the employer is not obligated to bargain with it. After a union has won an election and negotiated an agreement, it faces the problem of member apathy. Many members do not want to continue supporting union activities or paying union dues. Consequently, unions have designed several arrangements to assure continued membership. A closed shop requires that only union members be hired. Applicants for employment must already belong to the union. The Taft-Hartley Act outlaws a closed shop, except for hiring halls in the construction industry, but they exist anyway in such industries such as longshore workers. A union shop requires everyone who is hired to join the union within a prescribed period, usually 30 days. Temporary workers, part-time help, and student interns may be exempted from membership in what is sometimes called a modified shop. Union shops are not legal in the 22 states that have right-to-work laws. An agency shop recognizes the union as the bargaining agent for both union and non-union employees and requires everyone to pay union dues regardless of whether they are members or not. The fees, called agency fees, are usually deducted from employees' paychecks and are intended to prevent non-members from sharing the benefits obtained by the union's collective bargaining without sharing the costs incurred. Agency shop clauses are also illegal in states with right-to-work laws. A maintenance of membership shop requires that employees who join voluntarily must continue paying their membership dues until the present contract expires. A dues checkoff provision allows union dues to be paid directly to the union by the company's payroll office if a member signs an affidavit agreeing to such a payroll deduction. Union members can insist, however, on paying their own dues, which usually results in delinquent accounts. The Taft-Hartley Act requires companies to obtain written permission each year from employees to have their dues automatically withheld. Employees who do not have sufficient support among their coworkers to create an organized union can form a worker center of like-minded employees who function like an employee interest group. The major activities of worker centers involve picketing activities to protest company policies and attract the support of coworkers and the public. The right to work issue resulting from Section 14B of the Taft-Hartley Act has created an ongoing debate. What are the arguments for and against the right to work clause? The basic issue is whether everyone should be required to join a union if the union wins an election, or whether individuals should be free to abstain from joining the union if they choose not to. On one hand, workers who are concerned about individual freedoms claim that being required to join a union deprives them of their free agency in being able to obtain employment and work at a job of their choosing, free from interference by a labor organization. On the other hand, individuals who are concerned about union security claim that it's unfair for an individual to work alongside other union workers, enjoying the blessings of their efforts, dedication, and sacrifices without having to join the union, pay union dues, or accept the normal obligations of a union member. Since only 40% of the states have passed a right-to-work law as provided by Section 14B of the Taft-Hartley Act, there is apparently much room for debate on both sides of the issue. A right-to-work state are states that have a state law that secures the right of employees to decide for themselves whether or not to join or financially support a union. The states on this slide in turquoise are states where employees are free to decide to join the union. The states in gray are states where, if there is a union, the employees are required to join the union if they receive all of the benefits the union offers. The NLRB handles about 25,000 cases each year. Only 1/3 of the complaints are found to have merit, and of these cases, 90% are settled. Many charges are dropped after a contract has been successfully negotiated. Other cases are dismissed by the NLRB because they're trivial or because the NLRB does not have enough time to handle them. The NLRB faces a constant challenge to improve its efficiency since the full procedure from charge to complaint to hearing by a law judge to board ruling normally requires a full year. An unfair labor practice is any action by either the union or management that is prohibited by law or NLRB rulings. Every case originates in one of the regional offices as a charge or petition that has been filed by an individual organization. Unfair labor practice charges can be submitted in person or by mail, and they must be filed within 6 months after the alleged practice was committed. The regional offices of the NLRB investigate the charges by assigning a field examiner or an attorney to take written statements and affidavits from available witnesses. Regional offices try to dispose of the cases informally through withdrawal, settlement, or dismissal. If a case is not closed by one of these informal methods, a formal complaint is issued by the regional director to the general counsel. The general counsel may dismiss the case. This is the preliminary NLRB investigation and settlement agreements formal and informal procedure. Before complaints or a case goes before the full board, a formal hearing is held. An administrative law judge conducts the hearing according to the rules of the evidence and procedures of the United States District Courts and then issues a decision. Any party that disagrees with the judge's decision may appeal to the 5-member board of the NLRB. After the NLRB issues a decision, a dissatisfied party may appeal to the Federal Court of Appeals and then to the Supreme Court to review the case. This process may take several years. In a typical year, about 50% of the NLRB's rulings are appealed and approximately 85% of these rulings are upheld. Many of the unfair labor practice charges submitted to the NLRB arise from improper campaign activities, such as interference, restraint and coercion, threats of reprisal, promise of benefits, solicitation of grievances, restricting employee activities, surveillance and interrogation of employees, inciting anti-union activities, discrimination for exercising rights, discipline or discharge for union activity, and no solicitation rules. Prior to the passage of the Wagner Act, many companies established company unions for the benefit and support of their employees. These company unions, however, were run by management and did not serve as effective bargaining representatives of the employees. To eliminate this situation, the Wagner Act declared that company-dominated unions were illegal. Section 8A2 declares that it is an unfair labor practice for an employer to dominate or interfere with the formation or administration of any labor organization or contribute financial or other support to it. Therefore, companies are not allowed to participate or assist with the formation of or administration of any labor organization or to contribute either financially or non-financial support to it. Employers must use caution in creating quality improvement committees that include members of both management and labor. The quality movement has prompted many organizations to implement employee participation teams to improve productivity, quality, and efficiency. The effectiveness and importance of these committees is indicated by their continued use and popularity among both employers and employees. The NLRB has ruled, however, that these programs may be considered employer-dominated labor organizations, which are prohibited by the NLRA. When the NLRB finds an employer or union guilty of unfair labor practices, it has the authority to remedy the problem. Three of its most common remedies include ordering the guilty party to bargain in good faith, reinstating employees who have been terminated, and issuing cease and desist orders.